Since you already introduced the title, I will just start with the outline. Today I will mention the Budapest Convention on Cybercrime, and then the second additional protocol to the Budapest Convention. And thirdly, I will tackle the Convention 108 Plus, which is brand new, and I will conclude with some remarks on both conventions. So to start with the Budapest Convention, you can call it also Convention on Cybercrime, which is also known as Budapest Convention on Cybercrime or Budapest Convention. Since you already introduced the title,
really crucial
I will
because
just
it's the first
start
national
with the
treaty
outline,
which addressed cybercrime by harmonizing national laws,
because back then,
and
then
then
the
we
second edition of protocol to the Budapest Convention.
2001.
And thirdly, I will tackle the Convention 108
in 2004,
which is
and back
brand
then most of the countries didn't even have proper
Today, I
cybercrime
will mostly
regimes.
concentrate
So it was really
on
crucial
the
that this
convention
convention showed them some guidelines how to tackle these crimes, and also it extended beyond the scope of the EU. First of all, it is adopted by the Council of Europe, meaning that it was already, you don't have to be a member of the EU to be a member of the Council of Europe, as all of you know. But it went also beyond the Council of Europe, and you see the expansion of this convention to Asia, to Latin America. We see Russia and China are missing. Also, they were missing back then too, because this convention does not only see some crimes, but it also foresees some procedures which is necessary, which makes it necessary for other states to have a cooperation between them. And these two countries saw it as a danger to their sovereignty. So apart from these two countries, we still see an expanded participation to Budapest Convention. So it aims, firstly, as I said, to establish a common criminal policy aimed at the protection of society against cybercrime. It is very crucial because, as in the example of love letter virus investigation, the US could not prosecute the Filipino hackers because back then in Philippines, it was not a crime to spread viruses. So without having a standardized set of crimes, we will have digital crime havens where most of the perpetrators would not be punished. Secondly, it also foresees some procedural regulations which facilitate the detection, investigation, and prosecution of cybercrimes, and it enables further collection of electronic evidence. And thirdly, since investigating cybercrime is beyond the capacity of national states, it is really crucial that this convention created a regime of broad international cooperation. If we start with the chapter 2, it lists some of the cyber offenses which needs to be regulated by the parties. As you know, a convention cannot see crimes and punishments, but it can at least oblige the partners to regulate this type of crimes. And it particularly mentions 9 offenses: illegal access, illegal interception, data interference, system interference, misuse of devices, computer-related forgery and fraud, offenses related to child pornography, and offenses related to infringement of copyrights and related rights. So all of these rights indirectly also tackle with the data protection. But still, when we think of the timing of the convention, there are new types of crimes which emerged and which are also need to be regulated, such as identity theft, grooming, cyberstalking. Cyberstalking is especially an issue because most of the countries have not regulated it yet. So if a convention foresees that cyberstalking should be regulated, it would have been nice. Also, cyberterrorism is missing. And some of the countries are criticizing the Budapest Convention because even though it indirectly tackles with the data protection, it doesn't have crimes related to data protection, directly related to data protection, such as unlawful recording of personal data and non-destruction of personal data. Today, I will mostly concentrate on the procedural rights, procedural obligations, but just to give an example that some of these crimes might be also problematic, such as illegal access. Mere prohibition of illegal access or criminalizing the access to whole, illegal access to whole or any part of the computer system might end up problematic because many countries had provisions that criminalize unauthorized access to computer systems, but who is competent to authorize them? It's basically not the parliament. Sometimes the administration decides, sometimes even the boss in your company decides what is the authorized way to access a computer. And you may end up in a situation like this. You're at work and suddenly you remembered that you forgot to pay your bill. And instead of using your phone, you used your work computer, which was not allowed to be used for personal reasons. So is it really an unauthorized access? And was the mentality behind creating this crime was criminalizing these kind of situations? As you see, sometimes this kind of regulations can go far beyond their scope. And maybe it's better to think of not criminalizing just illegal access, but having like special intent, such as accessing to data, or even looking at the end, having access to the data illegally. So that was just one example, but I'm not going to go into details of all of the crimes. And now I will mention the procedural rules, which are foreseen in Chapter 2 of the Budapest Convention to effectively investigate and prosecute cybercrimes. They include lots of expedited procedures, expedited preservation of stored data, potential disclosure of traffic data, production orders, which I will explain a bit further in the next slide. The others are a bit more obvious: search and seizure of computer data, real-time collection of traffic data, and interception of content data. As you can imagine, all of these measures have a potential to infringe data protection rights and right to privacy. So if we go into more details, expedited preservation of stored data allows the party states to order a person or a custodian to preserve a specified computer data, including traffic data. There is another measure which also requires expedited preservation and potential disclosure of directly traffic data. This time, the purpose is to identify the service providers which might have the relevant data. But at the same time, we should keep in mind that traffic data is not that innocent. Also, according to the European Court decisions, it's always the case that the traffic data is not seen more innocent than the content sometimes, because it can give a picture of the person, give even a very detailed picture on the person. So the third measure is production order. You can order a person in your territory to submit specified computer data, or you can order a service provider to submit subscriber information. The subscriber information is also not just the name, so it involves many relevant personal data. And the others, I think they don't need further explanation. Only I want to underline that in real-time collection of traffic data, there is a possibility to even compel a service provider to give traffic data, which is a far-reaching measure, I would say. So since the Budapest Convention foresees so many measures, it also has to counterbalance it by seeing it some privacy protection measures. And Article 15 is really crucial in that sense. But the problem with Article 15 is it leaves the conditions and safeguards to be regulated by the member states. So if the member state, the party to the convention does not foresee these measures in their domestic laws, then it's not really a real protection. But at least Article 15 foresees some minimum procedural standards, which says, for example, national law must provide for the adequate protection of human rights. But what is adequate protection of human rights? Remembering that these parties to the convention are not necessarily a member of the Council of Europe, they don't have to be a party to the Convention on Human Rights. And they don't have to have implemented other international human rights either. But at least the convention says you can take into account UN treaties, you can take into account any international human rights conventions, and it should be adequate according to them. But as in the example of Malaysia, which is also a party to the Budapest Convention, Malaysia is not a party to any of these mentioned treaties and conventions, and still a party to the Budapest Convention. So national law further must incorporate the principle of proportionality. Hopefully, national law must provide for judicial or other independent supervision. So these are the minimum standards foreseen by Article 15. And when we go into Chapter 3, we see that the Convention contains provision regarding mutual legal assistance, which is really crucial for the cybercrime investigations. And these obligations include sometimes extradition of the possible perpetrator, and they also foresee some provisions on spontaneous information. So all the aforementioned measures, such as preservation of computer data and traffic data, can be made even more spontaneously. The information regarding to them can be shared even more spontaneously, which means actually more infringement on personal data protection rights. And if we go further, Article 32 says even a party may, without the authorization of another party, access publicly available open source stored computer data, regardless of where the data is located. We can say that if a data is shared publicly, why can a state not access to it? But we should also keep in mind that these OSINT tools, these open intelligence tools, are constantly developing. And in Europe, there are so many regulations right now, for example, in the Netherlands, regarding OSINT tools, which at least limit their scope, which limit their data storage, which limit also access to private sector data. So when we look at these safeguards, and if we have an article like this in a convention, it might not really help raising data protection standards, which in Europe we see are evolving more and more. And now I will switch to the second additional protocol to the Budapest Convention. It further enhanced cooperation and disclosure of electronic evidence, and it was really ratified recently in 2022. And this protocol aims further improve cross-border access to electronic data, but to be used in criminal proceedings. So it's not for crime prevention, it has to be used in criminal proceedings. And it simplifies also cooperation between member states and third countries, particularly in case of emergency. This emergency case also came into mind after COVID-19. And there are procedures foreseen in this protocol, which further expedites the information exchange between the parties. And at the same time, the protocol aims to ensure a high level of protection for individuals and compliance with the EU data protection standards. But we will just see if it's really done a good job in the context of criminal investigations or proceedings pending before the courts. So only, as I said, for the criminal investigations or proceedings pending, a country can request for information directly from an entity that registers domain names located in another signatory country if the information is necessary to identify or to contact the registrant of a domain name. So Article 6 allows requesting information not only within the borders, but also beyond the borders. Article 7 allows to send an order directly to an online service provider in the territory of other signatory country to obtain the disclosure of specified subscriber information. So you can also demand subscriber information from a service provider directly, even if it's located in another signatory country. So let's dig into Article 7 a bit more. We are talking about direct requests to service providers, internet service providers, but we are also talking about so many countries with different cultures and democracy. So imagine a country just can access directly the information on service providers. Of course, there are some safeguards, but at least the possibility to refuse these requests should be foreseen very carefully, because otherwise there is a risk of infringing immunities and special protections accorded to certain people, such as lawyers, journalists, and whistleblowers. Article 7 further says that, for example, it could be a safeguard. Under Article 7, a country may say that an order must be issued under the supervision of a prosecutor or other judicial authority, or otherwise be issued under independent supervision. I underline prosecutor because prosecutor is not really an independent authority. In most of the countries, it's just a part of the prosecutors are part of the administration. So looking at the Court of Justice Tele2 Watson case, it particularly underlines law enforcement authorities' access to personal data stored by private companies must be made subject to prior review by a court or an independent administrative authority. So if we change it by a prosecutor, it wouldn't comply with the at least Court of Justice standards. It goes further and says, if the online service provider does not really comply in a timely manner or fails to comply with this request, the authorities of the country where the service provider is located can order the service provider to disclose a subscriber's information and traffic data. So if they refuse, the country they are located in can order them to share this data. And of course, I mentioned the case of emergencies, which is also important in the second additional protocol. So according to these procedures, each state shall identify a point of contact, which should be open 24 hours a day, 7 days a week. And this contact will receive and transmit all the requests seeking immediate assistance. And this assistance requires an expedited procedure again. So that's why if you are looking for an assistance in emergent case, at least you should clarify why it is considered as emergency. So Article 10 says you should demonstrate that there is an emergency. And of course, as in the Budapest Convention, second additional protocol also tries to tackle the protection of personal data. Article 14 is particularly important. And Article 14 says that the transferring party and the receiving party might be bound by an international agreement, which regards the protection of personal data and data transfers. If there's an international agreement both parties are a part of, then this agreement will apply. And if there is no international agreement, then the parties can come to an agreement and arrangement between themselves. If none of the above, then Article 14 foresees some safeguards itself. It foresees purpose limitation, quality and integrity of data, storage limitation, and other safeguards which are familiar to us thanks to the GDPR and Law Enforcement Directive. Yet, their regulation is left to domestic authorities. So these are not really safeguards which are directly imposable. If a nation state doesn't foresee these safeguards, then they don't exist. And the problem is, as I said, how will you refuse this request? The barrier to refuse to suspend the transfer of personal data is really high. And Article 14 says that there must be a systematic or material breach of the terms of this article, and that the material breach must be imminent. So why are we looking for a systematic breach? And it's so above the standards of refusing data transfers, which is a bit problematic also in this article. And as I mentioned, Cybercrime Convention and Protocol are really crucial to tackle with the cybercrimes, which is like an international phenomenon, transnational phenomenon. But the problem is all the parties who are a party to this convention are not necessarily a member of the Council of Europe, and which means that they don't necessarily implemented Convention 108 or 108 plus of the Council of Europe. And there's not really a procedure in this convention which foresees adequacy decisions or individual assessment of the legal framework of the third country parties. And furthermore, the protocol doesn't foresee any international cooperation between the parties' data protection authorities. And some parties might not even have a DPA or an independent DPA. So these are the main problems with the Budapest Convention and the second additional protocol that I see. And when we switch to the Convention 108 plus, first we should mention maybe the old convention, the Convention 108, which was really important because it was the first binding agreement of the Council of Europe concerning data protection. And it was adopted in 1981. It's the time when most of the countries didn't even have proper data protection regulations, and it guided them how to protect data, and it also made it possible to have such a regime beyond Europe. And what was particular about it is it was very coherent and it was not sectoral based. So it applies to public sector and private sector, even to national security. I underlined also national security because it's always becoming more and more problematic. As it's mentioned, the Law Enforcement Directive and the GDPR excludes national security matters. But what is national security is not crystal clear, because the wall between intelligence agencies and the law enforcement is disappearing, because we see even intelligence-led policing, meaning that the intelligence collection and acting upon intelligence are at the same hands, are getting more and more at the same hands. So in this case, excluding national security is not that easy and a vague concept. Then you might exclude even some jobs done by the law enforcement outside, and you would say it's outside the scope of the Law Enforcement Directive. Whereas the Convention 108 made it simple, it said it just applies to everything. And the additional protocol to the Convention 108 complemented it further, because it's not enough to have safeguards for personal data, but there should be also data export limitations, and of course, supervisory authorities. Additional protocol guaranteed these two. But of course, we are talking about 1981. So even though it contributed greatly to the development of consistency, it needed to be modernized. And that's why 108 Plus was opened for signature in October 2018. What is special about 108 Plus is it combines additional protocol and the Convention 108. So it implemented data export limitations and the duties and authorities of the supervisory authorities in the same text. So it made it easier. And it's also guarantees these rights to every individual, regardless of their nationality and residence. So no discrimination between citizens and third country nationals can be made if you are a party to the Convention 108 Plus. What are the differences? In the original version, we see the mentioning of fundamental rights, but human dignity was missing. It's also missing in the GDPR. If you type human dignity, you see it only once and not in the recitals. Whereas Convention 108 Plus starts with human dignity, which tells us that, in fact, human beings are not objects, they are subjects, and they shouldn't be just prone to surveillance and marketing all the time. That part I added based on the human dignity started in the preamble. But it's really crucial because it shows the mentality and the scope of the Convention 108 Plus, which is not about data transfers or security, but it's more really about ensuring human dignity and combining data protection regulations with this perspective. And in the old version, only the definition of data controller exists, whereas the new version is more similar to the GDPR. It is more detailed, so it foresees also the recipient and processor and their obligations. And also in the old version, we see it only tackles automated data processing, whereas in the new version, the processing doesn't have to involve any automated means, so it applies also to manual processing. And of course, the old version had limited rights, like having the knowledge about your data being processed in an intelligible form, a copy of the personal data undergoing processing, whereas the new one has very broad informational rights, the purposes of processing, preservation periods, the right of every individual to obtain knowledge of the reasoning underlying data processing, which is important also for profiling. So not only information rights, but we see a set of very developed rights, which is so similar to the GDPR. And it further foresees data protection impact assessments, data protection by design and by default principles, and most importantly, which was totally missing in the old version, data breach notification. actually, the previous protocol, the protocol foresaw supervisory authorities, but the Convention 108 Plus made it more clear, and it made their powers more clear. So they can make decisions, and data protection authorities can make decisions and issue administrative sanctions. My conclusion is, starting with the Budapest Convention and its second additional protocol, actually, of course, mutual assistance and fast response is very crucial. That's why we have all these expedited procedures. Yet, as I mentioned, the adherence to these conventions should be made maybe a bit harder, because all of the countries might not be a party to the Convention 108. Plus, there is a systemic lack of accountability and assessment mechanisms. Also, after you get a party, you should be really assessed more tightly. And there are not so many regulations which foresee rejection of data access requests based on the right to personal data protection. In most of the cases, you can base it on other grounds, like it's interfering with your public order, but you cannot really base it like you don't have enough personal data protection regulation regime. So there must be more assessment regarding the right to personal data protection. And there should be more room to refuse direct requests, which is important, as I said, in case of journalists, to protect also fundamental rights of everyone, particularly the right to privacy and freedom of speech. We see that thanks to the Convention 108 and also 108 Plus, data protection regulations are spreading all over the world, which is good news. Because when the globalization occurs, then it makes it easier to have a standardized set, and it makes it easier to make no compromise when it comes to fundamental rights for the sake of other powerful outliers. In that sense, it's really crucial to spread the access to convention more. That's why the Council of Europe needs to publicize policies on accession more, and Council of Europe should make it appropriate and transparent so that the other parties would feel also encouraged to join. So thank you very much for listening, and I hope I made it on time.